Intellectual property, which protects creativity and innovation, could be in form of a copyright, trademark, patent, industrial design, and trade secret. Is everywhere. IP series now has a podcast session which will focus on recent IP cases and development globally. So, if you have a question or you have a case you want us to review or talk about, send an email to ipseriesinfo@gmail.com. I'll take that again, ipseriesinfo@gmail.com. And with that, I welcome you to IP Series COVID-19 edition. My name is Rita Anweri Chinda, and I'm your host for today. Thanks for joining us. As tradition, we always have a case study for every IP series. And our first story for today is the recent appointment of Darren Tang of Singapore as the new Director General of the World Intellectual Property Organization, WIPO for short. His term will run for 6 years and commences on the first day of October 2020. So congratulations once again, Darren Tang. WIPO has done an amazing job so far, so we're looking forward to the next 6 years with you as the new Director General of WIPO. Now, our second story for today is coming all the way from Nigeria. Now, a couple of weeks ago, I found out that some copyright owners comprising of musicians withdrew the consent they had given to the Copyright Collection Management Organization (COSON) to collect their royalty because of the lack of transparency the CMO has shown over the years, not applying international best practice and taking enforcement issues seriously. Do you know that Section 6 of the Copyright Collective Management Regulation 2007 provides that upon reasonable notice of the copyright holder's intention to do so, they have the right to withdraw their membership of a CMO or the rights assigned to the organization in respect of any of his work. The regulation did not state what a reasonable notice should be, and that's the lawyer coming out. So moving forward, Section 5 of the said regulation also makes provision for what the rights of a member of a CMO is, which includes as follows. 1. Members shall be entitled to 1 vote with similar rights and privileges. 2. Every member, that is subsection 2, every member shall be entitled to obtain from the organization the following. 1. Annual statement of account. 2. List of persons that constitute the governing board of the organization. So if you're a member of any CMO, that's a collective management organization, have you ever requested for to get the list of the governing board of your collecting society? If you have, did you get one at the end of the day? Just let me know. C. Annual report of the governing board. D. Report of the auditors. E. Information on the overall amount of remuneration paid to any director or employee of the organization certified by the auditors. Now, Section 15 makes provision for the distribution of royalties. Now, I'm going to read subsection 1. It says, subject to the provisions of this regulation, a collective management organization shall distribute royalties collected to its members in a manner to reflect as nearly as possible the actual usage of works covered by its repertoire. Subsection 2 says the CMO shall establish a distribution plan that is fair and equitable based on a procedure acceptable to its members and information furnished by users. So if you're going to get royalties from any CMO, it needs to show the actual users, how your work was used by anyone. So section 22, which is the interpretation aspect of the regulation, states that a repertoire means the catalog of a copyrighted work which is administered by a collective management organization, while royalty means payments made for the exploitation of copyright works. So you see, if you are a copyright owner, you are entitled to royalties. That's another way of commercializing your, exploiting your work. So moving forward, I have a couple of questions which I want to ask my listeners. So if you're a musician and you're listening to me, are you a signatory to the letter withdrawing your consent from Custom, representing you and taking your royalties on your behalf? Have you ever gotten royalty from any collecting society in Nigeria? Let's start locally. It says charity begins at home. Is your copyright work properly documented? That means, does the Nigerian Copyright Commission have a copy of your work in its system? So basically, we know that copyright protection is automatic. However, for documentation purposes, advisable that you deposit a copy of your work with the Copyright Commission within your nationality, within your jurisdiction. That's where you are staying. Another question I have is, do you know the role of a collecting body or a licensing body, collective society, or a CMO? Now, if you don't know, that's why I'm here. I'm here to help you guys. So first of all, CMOs are, by the virtue of Section 39 of the Copyright Act, defined as Section 31 sub 1 says that a collecting society, also referred to as a society, may be formed in respect of any one or more rights of copyright owners for the benefit of such owners, and the society may apply to the commission. Now, the commission here means the Nigerian Copyright Commission, for approval to operate as a collecting society for the purpose of this act. So we already know that Section 1 of the Copyright Act, that's the Nigerian Copyright Act, subsection 1 lists literary works, musical works, artistic works, cinematograph works, sound recording and broadcast as works eligible for copyright protection. And for this IPCs, we are focusing more on musical works. So going forward, it says subsection 2 of the Copyright Act also lists the requirements, what is required from a society before it can be approved, and they are as follows: that 1, it should be incorporated as a company limited by guarantee. Its objects are to carry out the general duty of negotiating and granting copyright licenses and collecting royalties on behalf of copyright owners and distributing same to them. You have to comply with the terms and conditions prescribed by regulation made by the commission under this section. However, subsection 3 states that a society now it uses the word shall not, and we know shall, when shall is used in a law, it means that's compulsory, that's mandatory, shall not be approved if there's an already existing society that adequately protects the interests of that class of copyright owners. And subsection 4 provides that it shall be considered to be unlawful for any group of persons to purport to perform the duties of a collecting society without the approval of the commission, and shall be guilty of an offense. So basically, what subsection 4 is saying, that if you don't get the permission from the commission and you're acting as a collecting society, it's considered to be an unlawful act. While subsection 5 provides the punishment or the penalties for doing such, and this could be a fine of 1,000 naira for first conviction, and for other subsequent conviction, that if you're convicted again, you'll be fined 2,000 naira, or the imprisonment for a term not exceeding 6 months, or to both, that is such fine and imprisonment. Now, I think this subsection needs to be repealed, amended to fit the present time of IP in the digital space. I hope that the copyright bill has took care of this part. Now, another interesting subsection is subsection 8, which provides that for the purpose of this section, that collecting society means an association of copyright owners. So if you're a musician, you write books, you're a broadcaster, an artist, you're into sound recording. So if you have a literary, musical, artistic work, you could come together with the primary or principal objective that you guys will negotiate and grant licenses. You also collect and distribute royalties in respect of copyright work. So he also went further to say that group of persons could include or includes a body corporate. So now subsection 9 of section 39 of the Copyright Act provides that the commission, where it finds its expedient, can assist in establishing a collection society for any class of copyright owners. Now, section 1 of the Copyright Collective Management Organization Regulation 2007 lists the requirement for a grant of license. Now, if you look at subsection 2 of section 1, so remember we had earlier stated that in order for a collecting society to be established, it needs to obtain permission, get a license from the Nigerian Copyright Commission in order for it to operate in Nigeria. And then they now have the Copyright Collective Management Organization Regulation, which gets its enabling power from the Nigerian Copyright Act as section 39 sub 7. So we're looking at section 2. I'm going to read a couple of the requirements or the things they need to submit in order to get a license. So the first one is the certificate of registration in respect of the company issued under the issued under the Companies and Allied Matters, that's CAMA. You need the memorandum of association of the company. You also need the articles of association of the company. You also need a statement indicating the class of right or category of right owners in which the society owns right or intends to represent or act for. Then you also says that members of no less than 100 right owners representing the class or classes of rights to which the company is seeking a license to operate as a collective management organization, that is CMO, which lists shall indicate the signed consent of persons to belong to the organization or where the organization has been in existence that they are members of the society. So it has about up to 8 requirements for it. So we're also going to look at subsection 9, which provides that a license shall be valid for 3 years and may be renewed every 2 years. So with the procedure herein stipulated. So if you as a copyright owner wish to form a collecting body or collecting society or a licensing body, you need to apply for a grant of license from the Nigerian Copyright Commission, which will be for a term of 3 years and then also renew subsequently every 2 years. Now, section 3 of the regulation provides that a society, that's section 3 sub 1, provides that a society may at any time within 6 months before the expiration of its license apply in the prescribed fund of the commission for the renewal of the license. Such states that you must attach the following: an up-to-date list of its members, the current repertoire administered by the organization indicating the title of each work and right owner. So it's not just after getting the license you just sit and then you have to always apply, and then you do that 6 months before the expiration of the 3 years that was given to you. That was given to you. So moving forward now, we're going to talk about the role of a collective management organization as a CMO, or a collecting society, or a licensing body. Now the first one will be to collect royalties on behalf of the copyright owners. We distribute the amount collected based on agreed formula to the copyright owners. For further info, look at section 13, which talks on licensing and tariff, licensing and distribution of royalties. Then you also have another role of a CMO, or a collecting society, or a licensing body, is that it can agree on the type of licenses on behalf of the owners with the users of the work. You also act as an intermediary, that's the middleman between the users and the copyright owners. Take note that as a copyright owner, once you become a member of a collecting society, you must notify that collecting society about the work that you have created or you own, which will be included in the repertoire of the CM. And I told you earlier that based on section 22, a repertoire basically means the catalog. So you're going to list all the catalogs of your copyright work that will be administered by the collective management organization. Now another role of a collective society based on section 13 is that section 13 sub 3 is that in setting the tariff, a society may have regard to the following: that is, a monetary advantage obtained from the exploitation, the value of the copyright material, the purpose for which and context in which the copyright material was used, the manner or kind of use of the copyright material, the proportion of the utilization of the work in the context of exploitation, any relevant decision of the court or the dispute resolution panel, and any other related matter. Section 4, subsection 4 of section 13 also makes provision that the CMOs may enter into an agreement with representative trade association concerning the use of its repertoire by members of such association. So I'm going to talk about the list out the collecting societies that we have in Nigeria. So the first one, which is our major case story, is COSON, which means the Copyright Society of Nigeria, and they basically collect royalties for musical works. They authorize them to be licensed to the public, and for the commercial use of the musical works and sound recording in Nigeria. Then you have Repro Nigeria, which means reproduction rights organization, which are for creators such as writers, publishers, photographers. Then you have the AVRS, which is the Audio Visual Rights Society for cinematography. I think I'm forgetting one. So while I was reading subsection 13 sub 3, I did mention of that when setting the tariff, they're going to look at any relevant decision of the court or any dispute resolution panel. So what I'm talking about is that like I always say, for every relationship there's bound to be a dispute. So it could be between the copyright owner, and the collecting society. So they have, under the copyright CMO regulation, they have a settlement of dispute. So if there's a dispute between these persons, section 14 provides that where there's a dispute arising from any matter that falls within the purview of this regulation, it shall be referred to the commission, which may set up a dispute resolution panel to settle the dispute. So you see, they already have like an administrative mode of resolving disputes. So basically have to always go to court. Like I always advocate that instead of going to court, parties can always opt to settle out of court. So this is a form of alternative dispute resolution. Another thing I'll be talking about is other relevant section in the copyright CMO regulations. I wish my listeners and copyright owners should take note of is compensation of license, which is found in section 16. It provides that every CMO shall provide for compensation, refund, or any arrangement which may apply in the event of a user is unable to utilize the license issued to it by the CMO, which situation arises as a result of the negligence, misrepresentation, or any other fault traceable to or caused by the collective management organization. So basically, like I said, a copyright owner can commercialize the work through licensing, selling it, or assigning it. And it states here that a copyright owner can be compensated if the fault is found to be from a CMO. So another section we'll be taking note of is section 20, which talks on existing collective society. It says here that an existing collective society management organization approved or whose approval has been renewed at the time this regulation came into force shall be deemed to be licensed under the regulation. So that's it. So if you have the opportunity, just go through the copyright CMO regulation 2007, read everything and get accustomed to. So what's the takeaway from this? Copyright owners in Nigeria should know that they have rights, especially if they are members of a collective society or a licensing body, that they can always withdraw their consent, which is what section 6 of the regulation provides for you. So you need to know the powers you have. Section 5 makes emphasis on your rights as a member of a collective society. So don't just sit down there or leave everything to the society and keep saying they're not doing anything for you. Stand up, ask questions. If you don't ask questions, you're not going to know anything. So in signing off, basically, so I really don't even know what to say. So in signing, I'm just going to thank everyone for listening. If you have questions, please send it. Don't forget to ipseriesInfo@gmail.com. We have to work together to make sure that we have a good structure in the entertainment sector and every other relevant IP sector in Nigeria. So until next week we have a very, very, very interesting case which was trending like 2-3 weeks back in Nigeria to talk about. So I hope that we all had a good time listening to me. If you have questions, send me a message on my Twitter at Esmeraldo99 or to the email I already called out earlier. So till next time, signing out. Rita and Regina. Thank you guys for listening. Bye.